Hi friends, welcome to my channel. This is a girl Mercy. If you're a returning subscriber, I appreciate you. If you're new to this channel, please hit the subscribe button. Subscribe to this channel, share this video, and I know that someone out there will benefit from the tips I'm sharing in this channel. This channel I talk about law practice, I talk about tips for excellent practice, life of a lawyer, excellent lawyer, what to do, how to go about it as a lawyer, how to improve yourself, how to improve your career, and above all, how to get it right as a lawyer. So today I'm going to talk about how to discharge a surety in a criminal proceedings. You know, when an accused person is brought to court and is charged to court, bail is, if it's a bailable offense, bail will be granted. Now, when a bail is granted, part of the bail condition could be for him to produce get a surety who might have a landed property, or depending on the grade level 16 civil servant. There are different terms and conditions that might be part of it, the bail terms for the accused person. Now, a surety will be brought. Now, sometimes, in reality, most times, most of the people go out to fetch professional sureties, but that will be a video I will do on another day. Now, or they could have family members, friends, and well-wishers who are willing to stand in for them as a surety. Now, the liabilities of a surety is very, 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 very huge. So the ability to understand who a surety is and those liabilities is very key in standing as a surety. Now, lawyers are not advised to stand as sureties to their clients, no matter the situation. It is professional that you desist from standing as a surety to your client or to whosoever, because the liabilities are far more than whatever financial benefit you're going to get in it. Now, as a surety who wants to be discharged from the obligations required of him or her in a criminal proceeding, what you're going to do is to bring an application. Now, as a lawyer to the surety, you file an application via motion and notice which will be served on the prosecutor or whoever who is prosecuting the matter, or to also be served on the accused person. Now, with respect to discharge of a surety, you can bring your application under Section 134 of the CPA, Section 351 of the CPC, or Section 177 of the ACJL, or Section 129 of the ACJL, or 177 of the ACJA, as I earlier said. Bring your application under these provisions of the law, and I pray that the applicant, which is a surety, be discharged from the liability obligations. Now, you can count your prayers like an order of this honorable court, totally discharging Mr. AYZ from suretyship, bond, and recognizance of the bail of the accused person in this case. The second prayer will be an order releasing to Mr. AYZ the copies of his title documents relating to the property known as 34 Mizel Street, Ikoyi, as it states where it is situated. You deposited by the applicant, which is the surety, as part of the fulfillment of the bail conditions or bail terms of the accused person. Then you put in the omnibus prayer, which is there for further orders or such further orders the court may deem fit to make in the circumstance. If there are other documents that the surety has deposited with respect to the bail, to satisfy the bail condition, he can state it, asking the court to release those documents to him or her. Now, in the affidavit in support of your application, you have to state when the bail was granted, what was the bail terms, the date, now what you deposited as a surety, and the reason why you're applying to be discharged from the liabilities. It could be that you're no more friends with the accused, and therefore you cannot be able to ascertain his whereabouts or know anything about him, and that because you cannot ascertain where he is at any time, or you don't relate with him again, you cannot stand as a surety for him because you do not know his whereabouts. That's a valid reason. There could be other reasons. Yes, why you want to be discharged as a surety for an accused person. Now, know that upon the death of a surety, before the recognizance is forfeited, his estate shall be discharged, meaning discharged from all liabilities with respect to the recognizance. Look at Section 131 of the ACJA, Section 179 sub 3, yes, of the ACJA. So be careful